Right, it is 1 minute past one, so I'm going to make a start. Hi everyone, thank you for joining us on your lunch break. My name's Jade Ferguson. I'm a barrister at Park Lane Plowden who specialises in healthcare law, so court of protection, medical treatment, clinical negligence. And joining me today is my colleague from Park Lane Plowden, Rebecca Musgrove, who's a specialist court of protection and family barrister. And we're here to discuss the Supreme Court's decision in the Attorney General for Northern Ireland reference. I'm hoping that we start using a bit of a nickname for it because it is a bit of a mouthful. So I'm going to refer to it as AGNI throughout this just for ease. By now, I think most of you will probably have had a chance to read through the judgment or will at least have picked up on some of the headlines. Now, the Supreme Court decision was to overturn Cheshire West. It's an extraordinary step and one that I found quite surprising. Cheshire West has been the foundation for deprivation of liberty law for over a decade. It's shaped practice across health and social care and underpins hundreds of thousands of DOLS authorisations and COP decisions. So this judgment really has changed the landscape completely. The Supreme Court did not, as I suspected it would, refine the law, but it instead has fundamentally changed the way that we are now to approach deprivation of liberty. So we're no longer using the acid test, and in its place, we now have this two-stage analysis, which requires us to both consider the objective assessment and also objective assessment of deprivation of liberty, and then the subjective assessment of valid consent. So this afternoon, Rebecca and I will take you through what all of that means in practice. We'll start with the foundations and remind ourselves of Article 5 and briefly revisit Cheshire West before turning to the Supreme Court's new approach in this two-stage test. We'll have a look at some examples of what is and is not likely to amount to a deprivation of liberty and go on to consider the kind of practical implications of that and some difficult questions which I suspect will now arise. And Rebecca's also going to do a section on the implication on children cases as well, because this is a judgment that affects adult and children's social care.
If anyone has any questions, I'll monitor the chat as we're going along. If you just pop them in, and then we'll try and get to what we can at the end.
Thanks, Rebecca. Okay, so I'll make a start. We'll just have a quick look at Article 5. So before we can understand the Supreme Court's decision in AGNI, we need to remind ourselves where deprivation of liberty actually comes from. For our purposes today, there really are three key points. Firstly, everyone has the right to liberty and the security of person. Secondly, a person can only be deprived of their liberty in limited circumstances and in accordance with a procedure prescribed by law. And in the context of court of protection, we're usually concerned with Article 5(1)(e), which deals with lawful detention of persons of unsound mind. And then thirdly, if somebody is deprived of their liberty, they must have access to some mechanism to challenge that detention. So the important takeaway point from Article 5 is that it doesn't actually tell us what amounts to a deprivation of liberty. So the courts have been left to develop that over time, which leads me on to the case of HL United Kingdom, often referred to as the Bournemouth case. So in HL was an autistic gentleman with profound learning disabilities who lacked capacity to consent to an admission to hospital. He was admitted informally to Bournemouth Hospital and was compliant with the arrangements there. He wasn't actively resisting the admission and therefore he wasn't detained under the Mental Health Act. The difficulty in that case arose because he wasn't detained, technically speaking, but also he wasn't free to leave either. So this is the case that reached Strasbourg, and the European Court of Human Rights held that he had in fact been deprived of his liberty. The main problem was not actually the restrictions themselves that had been put in place, but the problem was that there was no clear legal framework for governing the detention and no means of actually challenging that detention before a court. So the court found that there was a breach of Article 5, and it exposed a significant gap in our domestic law in relation to challenging detention. So what was the impact of Burnwood? Well, it was the creation of the deprivation of liberty safeguards. So in order to ensure that where somebody is deprived of the liberty, there's this lawful process and appropriate safeguards in place. And that led to the introduction of Schedule A1 of the Mental Capacity Act and the familiar framework we know today, kind of the capacity assessments, best interest assessments, RPRs, and all the review mechanisms that we now have. Now, for the last 15 or so years, it's been that framework within which deprivation of liberty has been assessed and authorised. And the question came up of, well, what is a deprivation of liberty? Which is how we then got on to Cheshire West. Now, I know you'll all be familiar with Cheshire West, so I'm not going to teach you all to suck eggs, but I will very briefly run through it. So the Supreme Court confirmed that deprivation of liberty requires 3 elements: objective confinement, a lack of valid consent, and state responsibility. And the important test from Cheshire West is, of course, the acid test. A person is deprived of their liberty if they are under continuous supervision and control and are not free to leave. And Lady Hale was very deliberate in rejecting a number of factors that had previously been thought relevant. She was clear that it didn't matter that the arrangements in place were benevolent. It didn't matter that they were in the person's best interests or that the person seemed content with them. And it didn't matter that the arrangements looked normal for somebody with that person's disabilities. So the result was a dramatic expansion in the number of situations considered to be a deprivation of liberty. We've now, from the new Supreme Court judgment, had an approach which is completely overturning that and bringing in a new test. So what is that new test? Well, just to be clear, the acid test no longer applies. As we'll go on to discuss a bit later, it's kind of part of the formula, but just one of many considerations that we need to have a think about. So instead, the court has returned to a much broader assessment of the person's actual circumstances. So the Supreme Court has said we have to look at the whole picture. So what type of restrictions are in place, their duration, the impact on the individual, and the way in which they're implemented. So it's much more holistic. And what I think is particularly striking about the judgment is that it's far less certain than the test that we had in Cheshire West. Under the acid test, we might not always agree, but at least we were asking the same questions. Whereas now we've got a much more evaluative exercise where we're considering lots of different things. And as a result, I think it's safe to say we can expect a significant amount of cases over the coming months as the courts try to identify where those new boundaries lie. Now, as I explained in the introduction, there's actually 2 stages to this test. So there's the objective analysis of deprivation of liberty, and then a subjective stage, which is in relation to consent. So looking at that first stage, the objective stage or a multifactorial test that we have to apply, the Supreme Court's starting point was the case of Gazzardi and Italy. Now, interestingly, Gazzardi is not a health and social care case at all. It actually concerned restrictions imposed on an individual in a criminal justice context. And what the European Court said in Gazzardi was that you can't determine whether there is a deprivation of liberty by just looking at one single factor alone. Instead, you've got to look at all of the restrictions cumulatively. And that's the approach that the Supreme Court has now adopted. So this case is how we arrive at this paradigm case comparison. So the question becomes, how close is this restriction to the paradigm case of deprivation of liberty? So how close is this restriction to confinement in a prison cell? So we're looking at something entirely different to what we were looking at in Cheshire West. Under Cheshire West, ordinary care arrangements could amount to a deprivation of liberty, whereas in AG&I, applying this paradigm, the starting point now is whether arrangements bear kind of sufficient resemblance to detention in the ordinary sense of the word. So the closer P's everyday experience is to being in a prison, the more likely there is to be that deprivation of liberty. My interpretation of the judgment is that only the most restrictive cases are actually likely to satisfy that threshold. But we'll come on to now as to what types of things we need to think about. So the factors set out by the Supreme Court included a whole range of things. They're not a checklist or a formula, and the court made it very clear that there's no single factor that's going to be determinative. We do have to look at the broad, wide picture when trying to assess whether there's been deprivation of liberty. So one of the factors to consider is the degree of the restriction. So can P leave the restricted area? How much control and supervision is there? Also the impact on P and whether there's any apparent acceptance or objection. Are they expressing that they want to leave? Do they seem distressed by the fact that the door is locked? Another consideration is medication. So is someone being sedated and that's what's stopping them from leaving or objecting? That's something that needs to weigh in the balance. The purpose of the arrangements. So is the aim to punish or control the person? Or is it that these restrictions are in place because they're needed to meet care needs and protect P? In addition to that, we've got the duration of restrictions, whether coercion is involved, and most importantly, the question comes back to how close these arrangements are to a prison paradigm. And I think particularly in borderline cases, it might be that last question that proves to be the most important one. One thing I would stress is that these factors all interact with each other. So, for example, P might have locked doors and be distressed by that, but that might not be enough on its own to be a deprivation of liberty. However, if there's locked doors combined with restraint, sedation, inability to see family, then that is likely to lead to a very different conclusion. So again, just trying to hammer home that this exercise is much more holistic than it was under Cheshire West. Just moving on to the next slide. Thank you, Rebecca. It's in relation to disability and catatonia. And I think this is probably one of the most controversial aspects of the judgment. It draws a distinction between a person who is capable of exercising physical liberty but is prevented from doing so, from a person who, because of their condition, is incapable of exercising physical liberty at all. And the reason that there's that focus there is because Article 5 protects physical liberty. So the Supreme Court indicated that if somebody is unable to conceptualise leaving, so if they've got a profound mental disability, which means that they can't form in their mind kind of a wish or a thought that they could leave or could object or want to leave, then they're not being deprived of a liberty which they possess. And equally, a person who cannot physically exercise freedom of movement, so somebody who has profound physical disabilities is perhaps unconscious, again, they're not able to express that freedom, so therefore they haven't been deprived of a liberty which they possess. And examples which the Supreme Court gave as individuals who fall outside of Article 5 are people that are unconscious, potentially people who are minimally conscious or catatonic, and it may impact people who have profound mental and physical disabilities. So many of the cases where we would previously regard the individual as being deprived of their liberty may not even fall within Article 5 at all, based on this judgment. And so it's perhaps not surprising that this aspect of the judgment has attracted some criticism from disability rights organisations. But I suspect that one of the major battlegrounds in future litigation is going to be this concept of being able to conceptualise leaving. What does it mean for someone to conceptualise leaving their current circumstances? What level of understanding is required? What about people that are unable to communicate or communicate non-verbally? And what if somebody's understanding fluctuates? So there's a lot of questions that are still unanswered, and I'm sure we're going to have a lot of fun dealing with all of that over the next few months as the courts try and work out where the parameters lie. Okay, moving on to kind of questions to consider. By this stage, you might be thinking, well, this all sounds rather uncertain. And I think this is a fair reaction to have, because under Cheshire West, we had a relatively clear test. Now we have a contextual assessment that requires us to stand back and examine the person's overall situation. And there's going to be all sorts of questions that we now need to ask ourselves when trying to work out if there has been a deprivation of liberty. And as I said before, it's not a tick box exercise, it's more about building up a picture. And the main challenge for practitioners and judges will be identifying when that picture crosses the line from being care and support into deprivation of liberty. So the next few slides I've got give us some examples of how the Supreme Court say the line should be drawn. So what does the Supreme Court tell us is unlikely to amount to a deprivation of liberty? The answer is quite a lot of situations, which would previously have triggered concern under Cheshire West will no longer likely be deprivation of liberty. So, for example, the court specifically says that locked doors within a care home will not automatically amount to a deprivation of liberty. And in a similar vein, arrangements that exist simply to meet a person's care needs, such as 2-to-1 staffing, are not necessarily deprivations of liberty. Now, the reason for this is that the court is placing weight on the purpose of the arrangements in place. So it's one of the factors that we now need to have a look at. So if these restrictions are in place to keep somebody safe, i.e. the doors of the care home are locked to stop P from wandering out into the street, or 2-to-1 care is required in order to transfer P, then the purpose of those restrictions points us away from a deprivation of liberty. And that's very different to restrictions being in place to try and control P. We've also got to look at the relative normality of the situation. So what would you normally expect to see if someone's living at home, or if somebody's living in a care home or other environments? So placements in a person's own home or in the community are now far less likely to amount to deprivation of liberty, unless those restrictions are particularly severe. So perhaps a circumstance where somebody's living at home, but the doors are locked, there's kind of 3-to-1 care, and also they're unable to see families often. The situation is going to be much more, the restriction is going to be much more significant in order to tip the balance when somebody's living kind of in the community or in their own home into a deprivation of liberty, compared to, for example, a psychiatric hospital, which there's a lot more control in that environment generally. So in addition to that, as we've discussed, there's individuals that have profound disabilities, may be unconscious, unable to conceptualise leaving. Those kind of cases are all also unlikely to fall within Article 5. So taken together, it represents a substantial narrowing of the concept of deprivation of liberty. But let's have a look at the other side of the coin. So what is likely to be a deprivation of liberty? Again, the court repeatedly returned to this prison cell analogy. The closer that the arrangements resemble detention in the ordinary sense, the more likely Article 5 is to be engaged. So this is important, particularly if certain restrictions are in place, such as physical restraint or use of medication or sedation, particularly where it suppresses objections or restricts movement. Another factor to consider is the social isolation or seclusion. And the court was particularly concerned about these kind of situations where a person is separated from others and prevented from maintaining ordinary social contact. Other scenarios that are important are, for example, high levels of staffing. As I discussed before, it doesn't necessarily mean that there's a deprivation of liberty just because there is a high ratio of staffing, if there's a good purpose for that. So if, for example, it's for care needs, a 2-to-1 is needed for transfers, less likely to be a deprivation of liberty. However, if high staffing is in place in order to stop P from trying to escape, or because P is particularly distressed and is objecting to the care, then that is more likely to be a deprivation of liberty. And perhaps most importantly, objection generally also matters as well. If a person's objecting to the arrangements, it's more likely to be viewed as a deprivation of liberty than somebody who appears to be content with them. And you'll hear when Rebecca takes over for the next part of the talk that there appears to be a little bit of an overlap with taking into account wishes and feelings in stage 1 of this test. And stage 2, which looks at primarily consent. So I think the overall theme to take away is that the court is concerned with genuinely restrictive and coercive environments, rather than what it would say is ordinary care arrangements. So if you've got a situation where it does appear to be nothing out of the norm care arrangement, it's perhaps going to be more difficult to argue that that's a deprivation of liberty now. So moving on to what this means in practice. Well, the first point to make is that if there's no objective deprivation of liberty, then no authorisation is required. And I'll come on to that a little bit later, but it does mean that there's thousands of existing authorisations which are now likely to not be needed or need to be reviewed. So local authorities are going to have to consider kind of all these authorisations under this new framework and perhaps come up with a system for reviewing these cases. But as I say, I'll come on to that in a bit more detail later on. I've been through stage one, a bit of a whistle-stop tour through stage one of this new test. So if the answer to stage one is that there is an objective deprivation of liberty, then the analysis doesn't end there. We then move to this new subjective stage two element, which is in relation to valid consent. So on that note, I'll hand over to Rebecca.
Thanks, Jade. I think we just had a question in the chat just about what the court is saying about medication. So I think we'll come on in a little bit to the examples of Mig and Meg, which I think helps us because in the Meg case, she was given medication and they were considering in that case whether the medication would mean that there wasn't valid consent or mean that there wasn't a deprivation of liberty. So I think just on the medication aspect of it in terms of the objective stage one test, it's not the case that if someone is prescribed some kind of medication that maybe has a sedative effect, that it's an automatic, that means that it's a dollar or not dollar. It's a bit more complicated than that. So if, for example, if you were prescribed an anxiety medication, but you only took that on an evening to help that person sleep, and during the day, when that person's very awake and very alert, they are very clear about what their wishes and feelings are, then that potentially is still very much valid wishes and feelings one way or the other. So it's really about if there is, I think for me, if there's a presence of medication in a case, that would immediately in my mind trigger, okay, I need to explore this in more detail and I need to ask more questions about when is the medication given, what's the purpose of it, what impact does it have on that person. And only once you've explored all of those things would you be able to really determine what the effect of the medication is. So I think in broad terms, what the court is saying, be cautious where people are prescribed medication because it may impact on their ability to give consent. It may make it a dole, it may not make it a dole. It really depends on the specific medication and the purpose it's given for. So stage two, the subjective element of valid consent. And I think this is the aspect of the test that probably sits most uncomfortably with everyone. How on earth do we work out what is valid consent or not valid consent? So the first thing is, it's really important that we do not confuse valid consent with capacity under the Mental Capacity Act. They are entirely different tests. The test that we're referring to in terms of valid consent is specifically in relation to Article 5. So where someone lacks capacity in respect of all the usual decisions that we assess capacity in relation to, so care and support, residence, sexual relationships, marriage, tenancy agreements, finances, they will still lack capacity in those areas. It's not changing the test that is in the MCA. It's purely about, are they able to consent to something which amounts to a deprivation under Article 5? Are they able to consent to that confinement aspect of it? So the issue of a person validly consenting applies specifically in relation to whether that individual has sufficient knowledge about their confinement that they consent, resulting in the confinement not amounting to a deprivation of liberty. So if there's valid consent, then in essence, there isn't a deprivation of liberty. And there's quite a number of different places where the Supreme Court talk about this within the judgment. So we put some quotes in there about paragraph 53. So, for example, someone could be conscious of their environment, has a basic understanding of their living circumstances, so that they can in some suitable way express their view about their situation and about that. So The important thing here, I think, to think about is you still have to have an objective deprivation of liberty in stage one. You don't get to the question of valid consent if there is no objective deprivation of liberty. So you're assuming that there is an objective deprivation of liberty, and you're trying to work out whether or not someone is content with those arrangements or not. It's a lower test than that in the Mental Capacity Act. So you don't have, there's none of this kind of weighing it up, retaining it, all of that kind of thing isn't there. Paragraph 172 talks about if someone has a de facto understanding of their situation and they're not expressing or manifesting any objections. So it's not necessarily even just about what they're verbally saying, it can be about their actions, it can be about their behaviours. And it's about how that comes together as a package in terms of valid consent. So part of the way that the Supreme Court have approached this is to say, well, some individuals may lack capacity under the Mental Capacity Act, but nevertheless, they can express wishes and feelings. And we know they can do that because we regularly put wishes and feelings statements before the court. And in essence, what the Supreme Court was saying is, well, actually, wouldn't it be doing them a disservice to discount their wishes and feelings and not upholding any valid wishes and feelings? So if they're quite happy and content with their arrangement, why should we then be subjecting them to deprivation of liberty processes and assessments and things like that, which is very intrusive and invasive? Shouldn't we be respecting their wishes and feelings and their general conveyance, whether that's through their actions or through their language or whatever it may be, that they're actually quite content with their arrangements? The obvious problem with that is obviously it does create this gap as to how do you determine that. I think it places an extremely high burden on local authorities to therefore try and work out whether something is valid consent or whether it isn't, because it's only if you're getting into it's only if you then establish there's valid consent that you then start triggering some of the processes for things like RPRs and IMCAs. So there's a number of quotes on the page here, which is basically kind of tells you that this is sort of littered throughout all of the judgment. I'm not going to read through all of them, but this is the sort of the examples that they're giving throughout the judgment. So when is consent not valid consent? So there is some helpful examples around this, albeit not anywhere near enough to be able to really help professionals on the ground. So clear expressions of disagreement, for example, not just, it may just be through their actions and behaviours, which might indicate that they're unhappy or disagree in some way. So there will be a category of obvious cases where people are objecting, and they will clearly not be valid consent. There'll probably be cases in the opposite direction that are at the other end of the spectrum where they're very definitely in agreement. I suspect a lot of cases will fall somewhere in the middle, because in essence, you're going to have to ask questions about, well, is this person's behaviour because they're in agreement, or is this person's behaviour, is it actually an objection to the confinement, or is it actually just that they're not happy with a particular aspect of their care plan, or maybe they don't like a particular carer, or maybe they don't like a medication? But it could be, it's trying to work out on the ground what any actions or behaviours or words say. So someone might not say, or verbally, you might not have any indications that they're objecting, but their actions and behaviours could be interpreted in many different ways. I think they're the cases that we're all going to be very concerned with. I think just a question says, how do you think basic understanding will be interpreted? I think initially I anticipate that judges will be probably quite cautious, I think as we all will, as to what a basic understanding is. I think one interpretation of the Supreme Court is that the bar is actually quite low for basic understanding. So do they understand, for example, that they can't leave? I guess how basic does that level of basic understanding? I mean, some people, you then get into the category of cases Jade was talking about, where some people just won't be able to conceptualize that, or some people might have a little bit of understanding. It might be that they can have a basic understanding with maybe some picture cards or with some very basic words or things like that. But I suspect judges will be cautious initially, But I do think there is a risk that the Supreme Court have set the bar quite low as to what is a basic understanding. Uh, I'll come back to Lisa's question in a second. I'll just finish this slide. So other things that are not a valid consent. So compliance or acquiescence may carry less weight if it's accompanied by the administration of sedative medication, which is capable of suppressing objection. So I think that goes back to Genevieve's question. And you're really going to have to get down into the nitty-gritty details of when the medication's being applied, what is the purpose of it, what impact is it having on P, is it suppressing their objections, or is it just helping them manage their anxiety? That's going to be quite difficult, and it might be a case of going back and looking at what things were like before they had that medication, for example, and were they clearly expressing objections before they were given this medication, and now they've got this medication they're not, which would perhaps indicate clearly it is suppressing something if all the other factors remain the same, for example. It does talk about where there's serious doubt about an incapacitous person's attitude, then don't draw an inference. I'm not sure if that's definitely enough of a safeguard, but I guess it's better than nothing. The only real thing that we have to go off at the moment is the Northern Ireland Draft Code, which is appended to the back of the judgment. And as I understand it, what Northern Ireland will be introducing is saying that views have to be consistent and have to be key. So if someone's views are fluctuating, then it's unlikely to be valid consent. Now, I think practically on the ground that creates an incredibly difficult position for local authorities, because the way the Northern Ireland Code seems to be obviously, I don't think it's actually been implemented yet, but the way in which it's drafted, it sounds like it will work so that, say, for example, you assess someone in week 1 and you conclude that they have valid consent, but the week after your assessment, they suddenly start expressing a lot of objections. That would, in essence, mean trigger a situation in which you as a local authority would then have to look at the issue of valid consent. So that seems to be the regime that Northern Ireland, or the impact of what Northern Ireland would introduce. Now, I don't know if the Department of Health and Social Care will implement something similar here. I think if they do, I think then that's going to arguably create quite a lot of work for local authorities. And I think in turn, what you're then likely to see is everyone being very cautious about valid consent, because you don't want to end up in a situation where you've then, as a local authority, you've said, yes, someone has valid consent, and then you're then having to review and go through the whole process again because the next week they've changed their mind. And then I think this probably leads to Lisa's question. So can valid consent be given where the restrictions are infringing Article 8 rights, or will restrictions on a person's Article 8 rights always continue to need court authorization? I think that's a difficult question, because I think one of the things the Supreme Court talks about is that there are safeguards in other convention rights. So I very much think that's a question up for grabs. I don't know the answer to that. I don't think the judgment, or I don't think there's anything either that I can recall that specifically addresses that point. So the answer is I honestly don't know. I certainly think that's a question which perhaps needs to be answered. And I think it probably falls under this category of, well, how do all these other convention rights protect people which now potentially aren't protected under the Dole's regime, under the Article 5 rights that they had before, because they're no longer considered deprived of their liberty. So the headline in terms of valid consent is, I think, proceed with caution. I wish I could give you some more concrete information. The judgment, I think, on the valid consent point is something which is, I think, it is incredibly difficult and very risky. Things which might help us. A lot of you, especially those of you who act for P, will be familiar with the case of ReRD about the duties and powers of RPRs. I've seen quite a lot of people say Mr. Justice Baker's list in this case around the useful principles about when a person has capacity and when they object might help us in understanding valid consent. I suspect this is a legal argument which at some point will be running a test case about whether this list is helpful or not. For now, it's the best we've got. It includes things like the obvious things. So what has P said? What are their wishes and feelings? What statements have they made? What's their emotional state? Is there any fluctuation in their emotional state? What's the impact of medication? any active attempts they've made to leave, what's the reasons for their behaviour. Even if they haven't attempted to actually leave, have they taken preparatory steps like packing a bag? What's their demeanour in relationship with staff? What are the records of challenging behaviours and triggers saying? What's their is the response to a particular aspect of their care? So it's a lot of the things that we all know. I think if in doubt, it's perhaps just something to go back to as maybe a checklist, albeit we're told where there is no checklist at the moment. I think we're all very much hoping that there will be some guidance produced, particularly for those of you in local authorities who are going to have to be undertaking these assessments, to try and assist you with at least maybe some questions or an updated form. Certainly in the Northern Ireland regime, it seems that they're going to have a specific form to record valid consent, where in effect you will set out and justify in writing why you consider that person to have valid consent, what's all the evidence, how you've weighed that up, and how you've reached that conclusion. That could immediately be undermined if then someone suddenly presents very differently. So we'll wait to see how that pans out, I think. We then get this, again, a rather tricky issue about, can someone else consent on behalf of Pete? Now, my understanding is no one addressed the Supreme Court specifically on this issue. So this is very much the Supreme Court seems to have taken a turn that no one expected and no one addressed them on in terms of the law. So I suspect this again will be subject to quite significant legal challenge because of the broad implications that it has. It, in essence, seems to say that potentially BIA assessors could provide valid consent, social workers, doctors, parents, next of kin, all kind of questions that are now in all of our minds. And the reason that is because what they say is that it may lead to the conclusion that the subjective element is assessed by reference to the view of the person with authority to make decision for the individual in their best interest. Now, there are a lot of people who can make decisions in the best interests of an individual. That could be a family member, it could be a friend, it could be the social worker who's doing the best interest assessor, it could be the allocated social worker, it could be the LPA, it could be a doctor who's making it. Really opens up a huge can of worms. It seems to set aside the decision in Reedy around parental consent, because this would seem to be completely at odds with that, and because parents would be an obvious set of people who could provide, who would normally make decisions and make in the best interest of an individual. And obviously what the Supreme Court said in Reedy, which was another Baroness Hale decision, was that actually parents can't consent for 16 and 17-year-olds who are deprived of their liberty. This would now, in this single paragraph, seem to say the complete opposite of that. So I think that's, again, another question which will no doubt be subject to a lot of litigation as to where did this come from, what really underpins this. To try and get some examples around valid consent, the Supreme Court gave us 3 examples. So in the original Cheshire West case, it can concern 3 different sets of cases. It concerned Mig, Meg, and P. Mig and Meg were siblings. Not that I think really matters for the purpose of working out whether this is a deprivation of liberty or not. So in Mig's case, moderate to severe learning disability, limited cognitive ability, communication difficulties, unaware of danger and risk. She resided in a sort of shared lives placement. I think she'd originally been with a foster care, and then she remained in that placement when she became an adult. There was no medication, no restraint, not locked in, never attempted to leave, had a relatively normal life, going on holidays and to college and things like that. The Supreme Court have said that Cheshire West was wrong to say Mig was deprived of her liberty, and in fact Mig is not deprived of her liberty. So that is a concrete example that I think you can try and maybe see if some of your cases have factors similar to this that might help you to try and work out, is it a deprivation of liberty or not, and is there valid consent? Similarly in Meg, so slightly different, because Meg wasn't in a sort of shared lives placement with her foster care. Meg was in an NHS placement with 3 other learning disabled individuals with complex needs. I think Meg is a case that we will all have dealt with quite often. Occasional outbursts of challenging behaviour, occasional physical restraint, but it's not a kind of regular thing that done. It tends to be to kind of protect her from harming herself or others. She is prescribed medication. So I think this is where it comes back to Genevieve's question. So Meg is an example where she is prescribed tranquilizing medication to control her anxiety. She isn't in a locked environment. There's occasional 2-to-1 support, but largely 1-to-1. She goes out with staff in the community. She goes to college, has a full social life. She doesn't want to leave. She otherwise seems fairly content with her arrangements. The Supreme Court say Meg was under Cheshire West. She was deprived of her liberty. She now is not deprived of her liberty, is what they've said in Agni. So I think that's probably as good an example as we have as to how the Supreme Court have applied to a concrete set of facts what would be the case in relation to medication, other than what they've said in other aspects of the judgment. But in Meg, even though she was prescribed tranquilizing medication for her anxiety, they've said she still was not subject to a deprivation of liberty. P. So P is one where the Supreme Court decided that they weren't going to say either way. And I think P is probably, like a lot of cases, that will sit in this grey area where none of us really know which way to call it. And it's going to be quite difficult to determine. So this is a 38-year-old man with cerebral palsy and Down syndromes, live in a staff bungalow with 2 other residents. He could walk a short distance, required prompting for all daily activities, living, eating, personal hygiene, sometimes required physical restraint with challenging behaviour. There was no medication for P. And what they've said is they haven't specifically, in Cheshire West, it was determined that P was deprived of his liberty. In Agni, they haven't specifically overruled that. So it seems for now that certainly it remains a good example of someone who is deprived of their liberty. What the Supreme Court said is there are some features that indicate he wasn't deprived of his liberty, but they haven't specifically overruled it. So I think P is perhaps an example of who is going to fit in that grey area and the types of cases we're going to have to ask the court to give a judgment on as to, and the type of case which inevitably we will all get wrong because we will all call it in slightly different directions because of the way this new test has now been established. So what are the practical implications? I think Jade's going to go through this with you, and then I will talk to you at the end about the implications I think it has on children cases.
Thanks, Rebecca. So what does all of this mean in practice? I think that the first point is that the existing authorisations that are in place, a lot of those are now not going to be needed and will need to be reviewed. So first of all, looking at the court-ordered authorisations, the starting point is to look very carefully at the wording of any existing orders. Some orders will impose ongoing positive obligations on local authorities to keep those arrangements under review in any event. That's to review them generally rather than just review them if they become more restrictive. And I know some judges have already started issuing directions of the court's own motion with directions asking for these kinds of issues to be addressed. Just this morning, I received an email from District Judge Temple copying in kind of northeastern COP practitioners attaching some suggested directions. So particularly in Newcastle, they're not issuing directions in individual cases, but it is clear from Judge Temple's email that she's urging parties to take the initiative and kind of have a roundtable meeting, try and get to the bottom of these issues prior to any hearing. If you have a hearing coming up in the next few weeks, I think you should assume that the issue raised by this case will need to be addressed. So I would strongly advise having an RTM to try and discuss and feel out what the other party's positions are and whether this is going to be a contested issue. And we're all collectively as a profession trying to get to grips with this new judgment as much as the judges are. So if you can put your position down on paper well ahead of the hearing, make sure skeleton arguments and position statements are exchanged and sent to the judge prior to any hearing, that will make the whole thing a lot smoother. There was also some guidance provided by Her Honour Judge Hilda to ex-judges It's about the key consequences of the decision, and any paper applications for renewal will need to be, you'll have to make it clear about what the restrictions are and whether they amount to a deprivation of liberty and why there is not valid consent. So if there is deprivation of liberty, but there is valid consent, there will, of course, not need to be an application. Moving on to the next slide, same applies to Schedule A1 authorisations. Local authorities are likely going to need to do a large review of existing authorisations, particularly where arrangements are those relatively typical care home arrangements, which are not as likely to fall under the objective limb of the new test anymore. And the reality of the situation is there's going to be a huge amount of reviewing needing to be done by the local authority, and the system is going to need time to adapt. So we're not in the position that we were in after Cheshire West, where overnight there was suddenly lots of people being detained unlawfully. Actually, it's a bit more freeing because it's kind of the opposite, where the authorisations are in place, but they're just simply no longer needed for some people. So there's not that rush there to correct them as there was after Cheshire West. The practical kind of standpoint is, well, you could simply wait for the authorisation to expire naturally, particularly if it's kind of coming up in the next month or few months, and review it at that point. But I think there has to be some pragmatism given the sheer volume of cases that are affected. So local authorities, again, I think I would just expect the cases to be reviewed within a reasonable time frame. So those with longer authorisations perhaps come up with a bit of a plan to review those before expiry, whereas the ones that have got a shorter time frame, it makes sense practically to wait for those to come up to expiry before you start reviewing them. Just generally on the broader impact of the judgment, there's approximately 400,000 deprivations of liberty authorisations in place at the moment. Some people have suggested that this may fall back to pre-Cheshire West levels, so it might potentially reduce down to 13,000 to 15,000. There's a lot of unanswered questions still, and we don't know how the court is going to approach these. So the next few months are going to be shaped by further guidance and kind of a lot of first instance decisions. So that leads me on to handing you back over to Rebecca, who's going to kind of drill into some of those questions.
Yeah, I think we just had a couple of questions from Shona and Lucy just about the re-ex procedure. I think all very good questions. So if re-ex situations, if there's no valid consent, will these now need to be Section 16 applications rather than paper applications? And the re-ex procedure streamlined applications we previously made for people who were not objecting to their deprivation of liberty, what will the re-ex procedure be used for now? I think they're all really good questions because in essence, where you were using re-ex for people who were deprived of their liberty but not necessarily objecting, in effect, you were just asking for the deprivation itself to be authorised. They fall away because arguably most of them, if not all of them, I suspect there'll be a few that maybe don't fall into the camp, but the vast majority probably just won't be dolls now. So arguably a large amount of the re-ex stuff will fall away. I mean, if we're going to go, if it's right, and only time will tell, if we're going to go from literally hundreds of thousands of cases to tens of thousands at best, then these are just going to go. I think Section 16, I think as Jade said just on that, I think it's on that previous line. So Section 16, I think, is going to be used a lot more because you're either going to have really obvious situations where there's a deprivation of liberty and there's no valid consent and peers objecting, in which case you may end up with your Section 21As, or you're going to have a situation where potentially it's not a doll anymore and someone is maybe giving valid consent for the purpose of the confinement, but they're unhappy about other aspects of their care, in which case you're going to use section 16, whereas perhaps you wouldn't have done that before. So I do think in some ways this might create additional burdens for local authorities to bring more section 16 proceedings than you were bringing before, because that section 21A process just won't be available to a large number of individuals now under this new regime. Questions to consider. So these are some of the questions we've sort of had, I think, either from colleagues or from clients in the last kind of week or so. So what forms to use? Great question. We don't know yet. As I said, Northern Ireland has seems to have drafted their versions. We're hoping that they will come very soon. I think, again, for those of you on the ground, most of your standard forms will now be very out of date. And so things are going to need to be updated very quickly, and we're hoping that's going to come from central government, because it would seem ludicrous if each local authority individually had to adopt something of their own, and inevitably that will mean someone does something slightly differently across the country, which will create a lot of confusion. What happens in situations where a person is objecting directly or indirectly, but the managing authority doesn't identify this? I think this gets to the heart of a lot of what makes a lot of us feel very uncomfortable about these new arrangements, which is how would that even come to light? And it places such a huge burden, I think, on local authorities to get it right. And to make really difficult judgment calls about cases as to, is someone validly consenting, are they not? But if it's not a deprivation of liberty, then there's going to be no mechanism through Schedule A1. If it is a deprivation, then obviously you've got the usual, you've got your IMCA, your RPR and things like that. But if it's not a deprivation of liberty, potentially, you might still have care reviews and things like that. You'll have best interests. You'll have assessments and kind of regular reviews and things. But there just isn't going to be a formal process for those people who are not counted as depriving of their liberty and or are deprived of their liberty, but it's valid consent. So again, it's not a deprivation of liberty. So I do think there's a real gap here in protections for some of these individuals. I don't know how that's remedied. Similarly, I think there are the gaps that are identified that Jade talked about earlier for the profoundly disabled individuals. I think the question for government will be, is it going to introduce additional safeguards and additional protections for people who now, in effect, overnight, have had some of those restrictions and protections that they used to benefit from taken away, it seems. But there isn't an obvious answer to some of these problems which are now arising. So what happens in those situations where a person is not objecting and their restrictions in situ are not proportionate or necessary? So again, this is where usually you would have used a lot of cases would have come under Schedule A1 to be able to challenge that. I think what you've now got is you've got care reviews, you've got best interest assessors and their duty to consult. You do still have advocates and things like that. And I think, again, this is where Section 16 is going to come into play. And it may be that these types of cases have to be brought under Section 16s, whereas previously they would have perhaps been Section 21As. Inevitably, whilst there may be a reduction in cases, which may help, I think, the public funding situation for local authorities in some ways, if they're having an increased burden of bringing a large number of Section 16 proceedings where they're the applicant, then perhaps it won't. We'll have to see how that pans out. What oversight and protection will there be to safeguard the vulnerable who cannot consent to their care and treatment? This is where I think, again, it gets very murky. So what we've been told is, well, there's Article 2, there's Article 3, there's Article 8. There's the phrasing around those of the profoundly disabled adults, which I just can't see that you can argue it doesn't leave them without protections. They clearly had additional protections and safeguards that they're no longer entitled to now. It's going to rely on care reviews. It's going to rely on best interest assessments and taking on board different views. And is it being challenged? Is it not? And then local authorities potentially taking Section 16 proceedings. But to me, that's an obvious gap that now exists that it needs to be remedied. I don't think that's something which can be remedied necessarily through the courts. I think that's going to have to be a legislative change that needs to be made. Whether it will be made, obviously, is not known. So children's cases, just briefly, the Supreme Court decision does apply as to what amounts for deprivation of liberty under all cases. So 16, 17-year-olds, under 16-year-olds as well. Some of you will bring cases both in the National Dolls Court as well as dealing with cases of children who then go in from the children's system into the adult system and move into the court protection. This applies across the board. This is a Supreme Court decision as to what amounts to a deprivation of liberty. So that objective test has now fundamentally changed. There isn't any specific case law or guidance on it yet. As I've said before, it does seem to overrule Re about parents being able to consent for 16, 17-year-olds, and it now seems to suggest potentially they can. Most cases are likely to be considered, I think, in respect of children in relation to that objective aspect of the first limb of the test rather than the valid consent. I think that will probably be the same for adults as well. In Re-AF, you had Mumby, who talked about children naturally live regulated and controlled lives, normal exercise of PR. I think, again, some of these comments and judgments will now be seen in new light. I think here I've kind of tried to give a couple of examples just to sort of help, but in essence, the same as with adults, that only those with a very high level of restrictions are likely to need authorization. So locking doors and windows, not automatically adults, same applies for children as adults. The 1-to-1, 2-to-1 care, again, the same. The Supreme Court do specifically adopt and say that the judgment of Mrs. Justice Leven in Re-SM from 2024 about the profoundly disabled 12-year-old is now good law. That was actually a correct decision, is what the Supreme Court say. That is an example where someone wasn't deprived of their liberty. So again, whether you're working in children and adults, that's probably an example of that, a practical example that you could look at the facts of to try and work out in terms of profoundly disabled individuals and whether they're going to be deprived of their liberty or not. We've already got case law around mobile phones. That's just to kind of repeat that. Physical restraint, again, likely to be a doll. Chemical restraint on medication, likely to be a doll. So it's the same principles as Jade went through for adults. I think one of the key things which is going to come up quite significantly and may mean that a lot of children cases are not considered dolls is going to be the purpose of those restrictions, because most of the time that you're imposing deprivations of liberty on children, whether that be 16, 17-year-olds or under 16s, it tends to be because you are trying to prevent them from some kind of harm. So whether that's criminal exploitation, sexual exploitation, or things like that, or therapeutic purposes, it seems like those kind of cases are going to be big factors in weighing up that multifactorial test, but are things which are going to point quite heavily, I think, in the direction of it not being a deprivation of liberty. This is kind of just a recap, so I'll send out these slides, but for those of you who do children cases, the attribution to the state is still there. I think one of the big questions that Agni opens up is Re-AF previously said that a local authority and a parent couldn't give valid consent to a deprivation of liberty. That was the Mumby decision in 2018. For the reasons we set out earlier, Agni seems to have the Supreme Court of its own volition seem to have suggested that individuals who are looking out for the best interests of P, the person who's been deprived, could potentially now give valid consent for the purpose of that second element of the test. So does that now mean that children's allocated social workers can give consent? Does it mean IROs could give consent? Does it mean parents or foster carers can give consent? I think all very much questions up for grabs, but it does seem to have changed the landscape, and obviously is a higher decision than that made by Mumby and Re-AF. So I think that's, again, going to be a question which we're going to need more answers to. And the new principle of the Supreme Court does seem to be in line with Nielsen, which said that a mother could consent to a child being placed in a psychiatric unit, which was something that wasn't necessarily accepted in Re-AF. And then just a little bit on children cases and valid consent. So Leven was overruled by the Court of Appeal in the Somerset case because it said that local authorities could never give, that the state can never give valid consent. Again, that seems to be that Leven actually might have now been correct, at least on the new reading. And then again, you've got, I've just, as I referred to that, you've got the Supreme Court decision in Re D, which now doesn't seem to be good law because of the change in scope that the Supreme Court have now introduced. Thank you all very much for attending. Does anyone have any questions? We've tried to make it as practical as possible, and with the aim of we all try and feel our way through this together in this new uncertain world. So if anyone has any questions, we're more than happy to try and answer. Nope. Okay. We will end it there then. Thank you very much for your time. We will send out a copy of the slides, and I think there'll be a link to the recording as well. You know where we are if you have any questions. Please do get in touch with us, and hopefully we will all get through this together. Thanks, everyone.
Thanks everyone for listening.
Thank you.